Remember, let's just put up there the first thing they filed, Shazam, number 2, and that was February 25th. This debt was created by SoFi Bank and subsequently transferred to plaintiff, which is LVNV funding. The last thing they said, SoFi Bank N.A. services loans that originate from SoFi Personal Loan Trust 23. So they went from saying SoFi Bank is the originator to now they're just servicing. Anybody can service, right? You don't own a debt, you can't sell the debt. So now for some strange reason, they're claiming SoFi Bank is a servicer and the original creditor is personal loan. And they doubled down in their evidence and trial brief, Shazam. Summarily, SoFi Personal Loan Trust 2023 is the original creditor. You just saw the actual paperwork that says SoFi Bank is. They're now claiming into the court several months later. Despite what the evidence and the law and the original creditor says, they're not the original creditor. The securitized trust is the original creditor. Why would they do that? So they tripled down and attached an affidavit to a summary disposition. So remember, I filed a motion to dismiss saying there's no documents. They came back with their response and they filed a motion to dismiss against my client and with this great affidavit, right? So let's put it up there, Shazam. First of all, in this affidavit, there's nothing mentioned about SoFi Bank. So weirdly, LVNV funding, again, stated in its brief, Shazam, essentially, SoFi Bank N.A., as seller and servicer to Resurgent, sent the debt to Resurgent, who then said it's LVNV funding. We only have 2 assignments. You're gonna see how weird that is. It's in their paperwork, even though they just said there is no SoFi Bank, after saying, yes, there is a SoFi Bank. So here's another affidavit they filed. They're just chock full of affidavits on the same date. Remember that? Let me put up that validation response from their law firm for May 13th. Shazam. That's the Roussin Brachetti Olivier, May 13th. Original creditor, SoFi Bank. Account was opened September 25th. Now they came up on the same day with another, this one's from LVNV funding, a witness swearing under oath, Shazam. And you can see from number 3, she's saying she has personal knowledge. So in order for this to be taken seriously under the hearsay exception to hearsay with the business records exception, she's got to say, I have complete personal knowledge, I handle all the documents for it to be taken as truthful. And she says the account was originated on September 25th, 2023. So if she had knowledge of the documents, she'd hold the most important document, which they brought in the trial as Exhibit 1, which is the loan agreement. We all signed a loan agreement, and the creditor was SoFi Bank, and the federal disclosure form that you have to give a debtor showing exactly how the payments are going to be made, how much the interest is going to be charged, and what's the total amount. It says September 24th. So she's familiar with these documents. She would know it would be September 24th. Think that's no big deal? Judge did, threw this out and threw out the evidence because they should know their own documents if they have personal knowledge.